All right, let's go ahead and get started. So again, thank you for attending today's webinar. My name is Vicki McMurchie. I am the Executive Director of the Dana Point Chamber of Commerce. We are very excited to have our panelists with us today. We have Chris Aiken of Aiken Cone and Javier Rivera Carbone of RCPC Employment Law, and they're going to provide an overview of the new 2021 California employment laws. Chris is going to be our moderator today, and Javier will be taking you through a prepared presentation with lots of pertinent information. We'll do a Q&A, and feel free to obviously throw your questions into the Q&A chat box down below, and then Chris will help to make sure that we're answering those along the way as well. We'll try to get to as many questions as possible. And again, we're just very grateful for your time and for both of these gentlemen to join us today. So Chris, do you want to take it away?
Thanks, Vicki. I appreciate it. So welcome, everybody. My name is Chris Aiken. I'm from the law firm Aiken Cone. We specialize in personal injury law. I'm also the chair of the San Clemente Downtown Business Association and have had a real privilege. And by the way, a very proud Dana Point Chamber member, and have had very great privilege of getting to know Vicki better. And I can't say someone that your organization is in great hands, and I really appreciate Vicki a lot. So thank you, Vicki, for having us. Anyways, I would like to, with Javier here, I would like to kind of preview this. In the last year, there's been a lot of employment updates, many new laws in the past year, and what Javier has done here is try to summarize those and kind of make it that we thought would be most applicable for the member of the Dana Point Chamber and their businesses. So what I'd like to do is, without further ado, is turn it over to Javier Carbone. He is an employment law specialist out of practice in San Clemente, has other offices. So Javier, why don't I turn it over to you?
Thank you, Chris. Thank you so much. You will notice during the presentation, and we have a copy of a PowerPoint, which is very, not many slides, but if you want to have a copy, you can download it. We're going to follow through and we're going to read it together, and I'm going to explain what is new. Chris is going to help me pass the pages. Quite frankly, I don't know how to do it. So he's going to keep me honest, but I want to share that we're going to talk about 7 things. The first thing we're going to talk about is the California Family Rights Act, or CFRA. The CFRA is a law that used to be applicable to employers that had more than 50 employees. So most chamber members, usually they don't have more than 50 employees. So this law was not applicable, but now the assembly has changed it. And now companies that have more than five employees need to comply with the CFRA. So we need to talk about that. Then we're going to talk about AB 5, which is the law that codifies court rulings that make the definition of who's an employee and who's an independent contractor. Then we're going to talk about COVID-19 because we have to, but specifically about the Cal-OSHA emergency temporary standards that were issued at the end of last year and they're going to continue through the pandemic. Then we're going to talk about some laws that can be relevant to all of us. And then we're going to switch and talk about the new updates to the pamphlets and publications that employers are required to give to employees at the beginning of the employment relationship. We're going to take some questions and answers. And if we have time, I would like to talk about illegal harassment. And actually, let me just say this about illegal harassment, because I'm concerned that we're not going to get to it. So my message is that we all are familiar with sexual harassment. We all kind of have an idea what sexual harassment looks like, but I think it's important to remember that illegal harassment comes in many forms, because the harassment can be motivated by different things like political affiliation, religion, race, color, and any of the 14 different protected categories under California law. So if we forget or we don't get to illegal harassment, remember this: there's a large menu on the items that can get employers in trouble when there is conduct motivated by any of those reasons against an employee. It is not just sex, it can be other things. Great. So with that, Chris, if we can put up the PowerPoint. All right, so on the next slide, we're going to talk about the California Family Rights Act, the CFRA. And The CFRA essentially gives a protected unpaid leave. Let me say that again, a protected unpaid leave. And what that means is that the employee who is entitled to take the leave is protected in their job, and the employer has an obligation to take them back when the leave ends, but it is without pay. And as I mentioned briefly, the CFRA only applied to employers that had more than 50 employees, and now applies to employers that have more than 5 employees as of the beginning of last month. But what is interesting about the CFRA is that it's not available to anyone. In order for an employee to be entitled to receive the benefit under the CFRA, that person has to have worked for the company for at least 12 months. And during that 12-month period, the person had to work 1,250 hours. So let me say it again. There's 3 requirements. First, that the employee has to work for a company that has more than 5 employees. Second, that the employee has been with the company for at least 1 year. And third, that that person has worked 1,250 hours. And this is a big deal because some part-time employees or some seasonal employees or some irregular employees are not going to meet the 1,250-hour requirement, whereas most employees are going to get there at some point in the first half of the year. The leave of the unpaid is up to 12 weeks. And I think we're, Chris, on the prior slide. We can go back to yes, thank you. So I was mentioning that it is up to 12 weeks during any year period. 12 weeks of unpaid leave available to an employee. But service members or people who are in the active military can take up to 26 weeks when the need for the leave is related to an injury during active service. And the reasons why people can take a CFRA leave are, number one, the birth or taking care of a newborn. This is called in the trade bonding. And what is interesting about the bonding is that as of last year, the parents could take up to 12 weeks, but if one company employed 2 people, right, the 2 parents, only one of them could take the benefit, but the law now specifically says that if the employer is the employer of both parents, both of the parents have up to 12 weeks. So it's something to consider because in some cases it may be a long time when the parents are going to be taking this leave. The second reason is the placement of a foster child or the adoption of a child. And what is relevant to mention with the placement of adopted children or foster children is that they're not necessarily babies. You see, we think about babies when we talk about bonding, but adoption can be up to the legal age and foster children the same. So it could be a teenager or it could be a situation in which it's a foster care or adoption, and the parent who's an employee can take up to 12 unpaid weeks of work. And the most important and the most common is to take care of the medical condition of a family member, the family member who has a serious health condition. So to be clear, if the employee has a serious health condition, the employee can take the lead for the employee to take care of the serious health condition. But the law says that the employee can also take this unpaid leave, CFRA, to take care of the serious health condition of a family member. Not just the immediate family member, but also siblings, grandparents, grandchildren, and domestic partners. That is new. It used to be limited to only the immediate family members. Now it's expanded. So essentially, any family member that has a serious health condition can qualify for a CFRA leave. Chris, if we can move to the next one.
Yeah, thank you, Javier. Let me, I do have a question that I'd like to pose to you. Real quickly, there's a little bit of feedback, just so you're aware of your microphone. So I don't know if that can be corrected a little bit, but I just want to make you aware of that. But the question is, how do you count 5 employees? Do owners count if they are on or not on payroll? That is the question that we have.
Yes. So on the feedback, I apologize. I don't know how to fix it. I have these things on my ear. Is it better now?
That's better now. It was kind of going in and out. I just want to make you aware of it if there was but that's all.
Well, thank you. This is a good question, and my response is, for purposes of CFRA, we look at the payroll, and if there are 5 names on it, then the employer qualifies. And I get it. I myself, I am an employee of the corporation that runs the legal business. So I am an employee, although as an owner, I am not going to take CFRA leave. But for purposes of qualifying under the CFRA, if the principals are on payroll, they do count. And that's why this is a sea change, and this is a big deal, because 50 was a high threshold to meet. 5 is very low. So chances are that most employers are now in the obligation of providing CFRA leave to their employees. If we move to the next one, we really talk about the employee's own serious health condition. Now, it excludes pregnancy. And the reason being is that pregnant women during pregnancy, they have other benefits available. And after the birth of the child, they can take CFRA for bonding, but they cannot take CFRA leave for a pregnancy-related medical condition. And other than making the leave available, it is important to be aware that the CFRA requires certain notice and documentation requirements. For example, if an employee says that they need to take time off because they have a serious health condition, that comment by itself may be enough to trigger the obligation of the employer to make it available. So to be clear, the employee doesn't have to use the magic words, I want CFRA. If an employee just says that they need to take time off because they have a serious health condition, or one of their family members has a serious health condition, we have to offer it and make it available. Also, we are able to require the employee to provide a medical certificate within 15 days of the need to take the leave. But that medical certificate, we have to take it at face value because of privacy regulations under EPA and other reasons that what we get may not be enough to justify the leave. So there's usually a back and forth and communication with the medical provider to conclude that in fact the employee is entitled to the leave. And finally, when the employee takes leave, the employer has a choice to allow them to use the benefits that they have, either at the same time as they take the unpaid leave or before they take the unpaid leave. And it is up to the employer to make that designation within 5 days. Now, I don't want to get too much on a deeper dive, but the concept is that when somebody leaves on an unpaid leave, we know we don't have to pay them. They just have a reason not to be at work. They can be absent. So are they going to get paid? And the answer is maybe. So concerning compensation, it is important to know that paid sick leave, which is now required by California, can be used for compensation during the unpaid leave. Also, personal time off or vacation benefit, if it's available, can be used for the employee to get paid. But the employees are also in a position to ask the state if they qualify to receive paid family leave, which is administered by the EDD, or to receive state disability leave, which is also administered by the EDD. My point being is that most of us went from not having to worry about employees taking unpaid leave, not worrying about paid family leave or state disability leave, to now being aware that we probably will have to make all of these benefits available to communicate with the employees when we have more than 5 employees. And finally, the job protection, which is that once the person leaves for up to 12 weeks, the employer has the obligation to bring them back on a position that is similar in the terms and conditions and pay. And this is a big one because a small company maybe can't wait 12 weeks. So this is something that needs to be handled on a case-by-case basis. Chris, let's go to the next slide. Now, maybe before we change the subject into the independent contractor or employee dilemma, Chris, are there any questions on the CFRA that we can tackle now?
No, Javier, I think we're good right now, but I definitely, if any of you have any questions, feel free to put them in the chat box or the Q&A box. I will definitely monitor that, and Javier is here to answer any questions.
I have a quick question. So just again, going over the 12 weeks leave, that's for the entire year. So they could do 3 weeks and then 4 weeks, and then like they could extend, they could take advantage of that whole thing throughout the year. It doesn't have to be 12 consecutive weeks, correct?
Yes, that is known as intermittent leave. So a person, if the condition continues, could, for example, take a day here, 2 days there, up to 12 weeks during the 12-month period. So you're 100% correct that it doesn't have to be a chunk at the same time. It can be in increments. Let me also, Chris, thank you for suggesting for people to make the questions on the Q&A also. Let me say this, if a question comes out later, please feel free to send me an email. I'll answer any questions within reason. The idea is that I can answer a quick question, right? Not to solve a legal problem, but within reason, I'll be happy to answer questions by email. My email is at contact information at the end of the presentation. But I want to talk now about the independent contractor or employee dilemma. And the reason why I call it a dilemma is because some people say, hey, wait a minute. I don't have to comply with this CFRA stuff because I don't have any employees. All these people here, they're independent contractors. They're not my employees. So I have no employees, no concerns about CFRA. And the response is like, what? No, so fast. Because in the last, frankly, 20 years, there has been a war between the status of employee, which means that a person is entitled to all the benefits and to all the taxes that the state of California requires, and independent contractors who are typically people who are on their own, they do their own thing, they pay their own taxes, they get their own insurance, and they pay their own Social Security and all of that good stuff. So like I mentioned, for the last 20 years, there's been friction because the California Labor Code assumes that any person that works for another, any worker, it is presumed to be an employee. So in order to be an independent contractor, some elements need to be present. And back in the day, there were elements that dealt with the control exercised by the principal. And if there was too much control of the work, then the person was an employee. So it was a sliding scale. The more control, the more the person was an employee, the less control, the person was an independent contractor. All of that changed when a number of decisions from the California Supreme Court came down, changing all of that. And what the California Supreme Court did in 2018 was to adopt a standard that was developed on the East Coast, which is known as the ABC test. And under the ABC test, instead of 20 factors, it came down to 3. And what happened was that for a couple of years, that Supreme Court decision went ignored, happily ignored by most people. And the governor decided to codify that decision and to make it into a law, which is now the famous or infamous AB5. So what AB5 does is to take what the Supreme Court had already said a couple of years ago and put it in a law that has the ABC test. And to summarize, the ABC test is number 1A, whether the worker is free from the control of the principal, right? And that's possible. It is possible to do that, not to have too much control over the person. The B is that the worker performs work outside of the hiring entity's course of business. Now, this is important because what the B of the ABC requires is that the person has to be in a different business than the business of the company. Let me say it again. The person has to be in a different business. And this is virtually impossible to do if you are hiring somebody who's going to give you work. The last point is that the worker is engaged in an independent trade, occupation, or business, right? So the example that I like to use is myself. I am an attorney, and if some of you hire me, you're going to ask me a legal question. I'm going to give you a legal answer. I'm going to send you an invoice. You send me a check. Everybody's happy. So I'm truly independent, and my business is different from yours. Chris, if we can go back. But let's say that I give some services to the law firm Aiken & Cohen. I am an attorney. They are attorneys. And now we are not able to pass the test because under the B, we are in the same business. we're both attorneys. So that makes it very, very complicated because some people have said that now it is impossible to have independent contractors. The good news is that the politicians have listened to some industries, and there's essentially 50 industry groups that have been able to carve out or to take out about 100 exceptions or limitations to AB5. So now it is possible to maybe qualify for some of the exemptions, and one of them is the business-to-business services, the professional services, creative talents, and some other exemptions. So the point I'm trying to make is that if you have independent contractors, be very, very careful, because chances are is that that status is not legal. And if you do, this is the time to make sure that they fit in one of the exceptions, that they fit in the box. Because it is possible maybe to have a relationship in which A, B, C can be complied with. But let's talk about the case of the Uber drivers, Door Dashers, and other app-based companies. They were unable to pass the test, because if you are Uber, right? People tap on their phone, a car shows up, and they're taken to a destination. If you ask Uber, they're going to say they are a technology company. They're not in the transportation business. And if you ask the state of California has taken the position that they are in the transportation business, because they give people and they charge people for transportation, and drivers are essential for transportation. So the Uber drivers cannot be independent contractors. The Dashers cannot be independent contractors because they are in the same business. And what these big technology companies did was to buy themselves an election. And during the last election cycle, Proposition 22 prevailed. So now under Proposition 22, technically, app-based companies may have independent contractors if they comply with those requirements and they offer the benefits that that law offers, which are a little bit different than the benefits, of course, less benefits that offered by the state as a regular employee. But the Proposition 22 is right now being challenged in court. I understand that some judges are thinking about not allowing for Proposition 22 to continue. So it is up in the air whether the AB5 is going to be the law and whether Proposition 22 is going to continue. And this is important for us because we need to know the relationship we have with employees. Now, changing the subject on the next slide. Chris, if we can go to the next slide.
This is the next slide. Do you see that, Javier?
Yes, thank you. I missed that. So this is a big one, the Cal OSHA. Let me take a step back. This is related to COVID-19. At the beginning of the pandemic, we all know that the governor, through the Office of the Governor, issued certain guidelines by industry in which the governor's office outlined adaptations that were necessary for industries to take in order to open or reopen and continue doing business during the pandemic. But all of that was under the authority of the governor as the chief health official of the state. Some organizations have taken the governor to court. Some have won, saying that the state overstepped their authority, and some have lost because the courts have recognized that the governor has that authority. But it really became all gray, whether it was mandatory or just a suggestion. And we had the state of California taking one position, and then we had the federal government through the CDC taking a different position, and it has been confusing for the last year. Then lo and behold, during the month of November of last year, Cal OSHA, which is the agency that is in charge of protecting workers and making sure that there are no harm to employees in the workplace, they developed their own regulations. So now, in a situation that was confusing, we have more confusion because Cal OSHA has issued emergency temporary standards that are going to be in place since Thanksgiving of last year until the pandemic ends. And the reason we're talking about this is because the emergency temporary standards, or the ETS, go above and beyond what the governor had required, up to the point that even Governor Newsom issued an executive order carving out certain requirements that Cal OSHA did, because even Newsom thought that they went too far. So we need to comply, and this is what it requires. Number one, the ETS requires employers to develop a written COVID prevention program. Well, that's not new. That was in the guidelines before. So all of you, I'm sure, have a written COVID prevention program. So it's just a matter of updating it to comply with the ETS. Second is to develop an effective procedure to investigate COVID-19 cases in the workplace. This is new. This is new in the sense that now we have an obligation to try to find the source of the infection. And, you know, whatever we can do in good faith, but we have to do something to try to investigate where the infection came. When there is a positive case, the employers need to establish the date of diagnosis if the person tested positive, or when the symptoms began. Some people don't have any symptoms. If there is a positive case, once we establish when the person was infected or when the symptoms began, then we need to determine if the person needs to be excluded from work. And let me say this is a big deal because this is brand new. Before, there was no obligation to exclude people. Now, under the ETS, the employer has an obligation to exclude the employee. And exclusion means that we're going to tell the employee not to show up for work up to 10 days. Actually, the regulations say 14, but the governor brought it down to 10. So right now it's 10 days. And according to CalOSHA, we, the employer, have to continue paying the employee for those 10 days. That's brand new. Nowhere in the regulations or guidelines before was the employer required to pay the employee, because that federal law that required emergency paid sick leave ended when the year 2020 ended. So there was nothing on the books, and now, because of this CalOSHA ETS, the employers have to continue paying for up to 10 days to the excluded employee. Something that is also new is that the employer has to give a written notice to people who have been exposed within 1 day of the determination that there has been an exposure. And if the person has been exposed, we have to offer them free testing. But if there is an outbreak, which is defined as 20 more cases in 14 days, then we have to offer free testing to all employees. To clarify that point, now that most counties are offering free testing, CalOSHA has said that sending our employees to get the county free testing qualifies as free of cost. However, it has to be on the clock. So if we have to send somebody who has been exposed to get a free test, we have to pay them for the trip. And finally, we have to investigate if the workplace conditions contributed to the risk of exposure. If there's something that we could have done, if there is an adaptation that we could take, CalOSHA requires us to look into that and to make all the changes that are necessary and take all the adaptations that are necessary to prevent the spread of the virus. Next slide.
Javier, there's a question. The question is, what date? There's actually a couple questions. The first one is, what date did this ETS officially start?
I believe it was November 27th, right after Thanksgiving, 2020.
Okay, and a follow-up question is this: what if everyone is working from home? ? Do we need to do this ETS if someone gets sick and has not been in the office for nearly a year?
Yes, that's a fantastic question. And the answer is no. If the person is working from home, right, then there is no exposure at work. And for that reason, all those steps that are necessary to protect the others become unnecessary. And the ETS says so. If somebody's working from home, then there was no exposure at work from others. So if somebody is working from home 100% of the time, then we are not required to go through these steps. Having said that, if the person is positive, my recommendation is that we pay them exclusion pay anyway. because, the regulations say if somebody has a positive, you pay them up to 10 days. And quite frankly, fighting that fight with the Cal OSHA is going to cost a lot more than 10 days of pay. But we can take that on a case-by-case basis, right? Now, we were talking about the virus, COVID-19, the ETS, and the points that I want to share on this subject is number one, exposure. The definition of exposure is if an employee has been within 6 feet of an employee who had the positive for 15 minutes during 24 hours. Let me say that again. During the last 24 hours, has the employee been in contact with the infected employee for more than 15 minutes? If the answer is yes, then there has been an exposure. And then we have to give them written notice that the person may have been exposed, right? Because if, let's say we have a mixed situation where some people are working in the office, some people are working from home. Look, if you're working from home and you're not here, you haven't been exposed. No obligation to give notice. If I work in the 9th floor and Chris works on the 10th floor, we don't see each other for 15 minutes, then there's no need to give notice. But for those workplaces that people are in close contact, we need to determine the exposure and who to give notice. And this has become a big deal in settings like manufacturing, warehousing, where you have dozens of people coming in and out, moving up and about, and to determine whether they have been so close as to trigger the requirement for notice. The second point we want to talk about now on the ETS still concerning COVID-19 is the exclusion. Employees who have a positive or employees who have symptoms cannot return to work for at least 10 days. Let me say that again. They cannot return to work for at least 10 days. And this is an issue because employees want to return to work, especially those that are asymptomatic. They have no symptoms, so they want to come back. Some of them even test negative. And they say, hey, I have a negative. I want to go back. And the answer is you cannot. You have to absolutely, positively stay out of the workplace for at least 10 days. And also, employees that have no symptoms have to stay out for at least 10 days. And we cannot, as employers, we cannot require a negative test for people to come back. And this is counterintuitive, right? Because if somebody has been infected, we kind of want to know whether they're still infectious, right? They still have the virus. And what the Cal OSHA has said and what CDC has said is that we cannot require a negative test as a condition for returning to work because some people continue to test positive even if they're not infectious. So the science is up in the air, and some people are still positive, but have no symptoms and allegedly not infectious. So that's why we have to wait the 10 days minimum up to 14 days and then allow them to come back without asking for a negative test. Make sense? And finally, the definition of outbreak. If there are 3 or more COVID cases within a 14-day period, the employer has the obligation to notify Cal OSHA and the local Orange County health agencies about this outbreak. We have to let them know. Frankly, I had a situation where I contacted the OC health agency and they didn't know what to do with the information. They said, like, what do you want? Said, well, we want to give you notice. And they're like, why? So this is all up in the air and it's kind of messy, but we have to go through the motions and follow the guidelines. And eventually they accepted an email as notice of an outbreak. But if there is a major outbreak, which is 20 cases in a 14-day period, do expect a visit from Cal OSHA. They're going to show up with some people and do inspections and try to set up more adaptations. I have seen it in the warehousing sector where adaptations are necessary and have become, part of the deal when a lot of people get sick. COVID-19, should we change the subject?
Javier, there's a couple questions. They may be related, so I'll do my best. First question is, I know that an employer can't require a negative COVID test in order to have an employee return to work, but are they allowed to ask for anything like a doctor's note, ? Or can I require it if I pay for the testing? On the flip side, can you require proof of a positive test in order to grant the time off?
Okay, so let me, and I apologize for asking you to repeat yourself. Let me tackle the first part of the question,
Sure.
or the first question first. And this is what I understand. May I, as the employer, ask the employee to give me a medical certificate that they can do the job, right?
Yeah, are they allowed to ask for anything like a doctor's note, or can I require it if I pay for the testing? That's the thing.
Well, the testing is different from medical note, so that's why I want to
Oh, okay, so maybe start with the medical note. I hear you. Yeah.
So step by step. So let's talk about the medical note. And here's my response, maybe. And here's why. The law that prohibits discrimination in employment does not allow for medical testing unless it is necessary to prevent either the employee or someone else from being injured, right? So if somebody has a medical condition that can cause themselves harm or can cause harm to others, we can require what is known as a fit for duty test, which is to say, hey, doctor, this is the job description. Can you, doctor, let me know whether this person can do these functions safely? And that's a return to work, right, fit for duty test. And that is allowed if there is a risk. Now, COVID-19, is it a risk? Some people will say, no, it's in the air, literally. So there's no need to have a medical test. And some people will say, yeah, if you bring the virus to my workplace, that's going to cause harm to other people. So I am going to require a fit for duty test. And my response is like, maybe this is a case-by-case basis analysis. It depends on how close people need to be together to do the test, but it is risky because the default rule is that you cannot ask for fit for duty tests unless there is a risk to others. And then the question we have to answer is COVID a risk to others? My opinion, yes, but somebody who's reasonable can disagree. And that has to be analyzed on a case-by-case basis. Now, the sub-question had to do with test. Can I ask somebody to give me a test as a condition of employment? The answer is no. And just because Kalosha says no. I personally think that's wrong, but it is the regulation, and my advice is let's follow it. So we're not going to demand for people to present us with a test. We're just going to either exclude or not exclude, depending on the symptoms or testing. Yeah. And I think that there's a second question, Chris.
There is, Javier, and let me frame it this way, because it's employees at home, but what if, and here's the question, what if the positive employee wants to work, has no symptoms, do they still have to take the 10 days off and get paid? Why don't I stop there? Does that make sense? Why don't we stop with that?
Yes, it does. Yes, it does. Okay, so let me give a two-part answer. If an employee is positive, we have to exclude the employee and pay them. Now, second part, what if this person works from home and they're not a risk to others? What does it mean to exclude them? Because I know that they're home. Do I have to exclude them from their own home and pay them? And the answer is maybe. When you read the regulations, it suggests that you have to tell people, look, don't work for 10 days because you have the positive. A reasonable interpretation can be like, look, if you're from home and you can work, do, especially people who have no symptoms and so on. But the basic rule is, the way it's written, is that anybody who's a positive, they have to be out of work for 10 days, no matter what.
And then there is a mention about reimbursements and an assumption the government's not reimbursing for this as they were in 2020. Any information on that? Does that make sense? About reimbursement?
Yes. That's a good question. So to take a step back, the US government had a law that requires for employers to offer emergency paid sick leave benefit of up to 10 days. And the way that worked is that any employer that gave that benefit generated a tax credit that can be used by the company. So it's not a reimbursement, it's a tax credit. And that ended on December 31st, 2020, because Congress did not include it in the package that they passed, and it's not, by the way, on the new package either. So that ended. But the Treasury, before leaving, the last Treasury issued a rule saying that if an employer voluntarily gives emergency paid sick leave, then they can claim the tax credit. But that is separate from what Kalosha is saying, right? In here, we have to straight up take the money out of our own pockets and pay it up. So the reasonable question is, if I pay somebody up to 10 days, can I talk to the Treasury and claim a credit against federal taxes? You know, that's an interesting question. And I think here's my response. Why not? Because if the federal government is saying that anybody that voluntarily pays can get a tax credit, I will shoot for it. Maybe you can get it. But on paper, the federal requirement is no longer a law, and Kalosha has its own requirement. Make sense? Great. So,
sorry, go ahead.
Go ahead. Oh, go ahead.
This is related, but I'm just going to say it. I think you've answered it, but there is another attendee that basically wrote, the employee cannot return to work, but they can continue to work from home, right? I think you've addressed it, but I just wanted to mention it.
Right. And my response is the way the regulations suggest that somebody who has a positive, they have to stop working for 10 days. That's the way it reads. If somebody wants to work from home, should we allow them to work from home? You know, my advice is going to be the most conservative route because, you know, part of managing the risk is taking the safest route. Now, can you manage this risk and say, well, if the person has no symptoms and they really want to continue working, can we allow them to work from home? My response will be if they want to. But then we get into this debate of whether, yeah, I was working voluntarily because that's who I am and I felt great. But some people are going to turn around and say like, oh my God, they forced me to work sick. So my advice is like, look, let's just take them out, leave them out, wait the 10 days and no one can point the finger at you. That's one way to manage that risk.
Thanks, Javier. That's the questions that are in the box right now.
So let's changing the subject on the new laws. There's many. For example, there is a law in California that says that public companies are required to have a board of directors that is diverse and inclusive and representative of the diversity of California. Well, if you're not a public company, you know, who cares, right? So there are many, many laws that are applicable to unionized workplace. There's even a law that deals with, you know, power generation, transportation, security guards. So there's many, many laws. It seems that the legislators were looking for something to do. So there's a whole bunch of laws that are new, but which ones make sense for us as a group? One that I think is a big deal is the pay data reporting. It applies to companies that has more than 100 employees. And even though most of us don't have 100 employees, I think it's important to be aware that now the state of California wants to know in an annual report beginning March of this year, the breakdown of the ethnicity, race, gender of the people who are senior, mid-level, professional, administrative, workers, and service workers. So essentially, they're asking companies to paint a picture, to say, tell me who are the executives, who are the non-executives, and in places where there's not much diversity, is going to be clearly shown that lack of diversity. So this is one way of the state kind of nudging companies that have more than 100 employees to see that they have an issue with diversity. The same happened a couple of years back, say 2017, when California passed a law that required for equal pay. When you look at the pay by gender, by job classification, you can clearly see it. When you have one person doing the same job and making different amounts of money, it just jumps up on the page. So this is another tool that the state is using to increase diversity. I just want to mention it just in case you hear it. And if it applies to you, the deadline is March 31st. Workers' compensation and COVID-19. This is not new. This is not new in the sense that the governor had issued guidelines and that the guidelines from the governors became law and that law now is part of the temporary regulations. But it is essentially two things. First, that if somebody gets sick at work of the virus, there is going to be a presumption that the employee got sick at work. Let me say it again. If somebody is sick and they work, the presumption is that they got sick at work. The consequence of that is, of course, that the employee then is entitled to receive worker compensation benefits because they got sick at work. Some people say that's great and fantastic because the employer has no other liability. You see, when somebody goes to worker comp, they cannot sue you because worker comp takes care of any damages. Some people say that's awful because now people are going to be making workers' comp claims when they got sick at home or at a party or at a game or a concert or at the beach. So it's unfair for us to have to pay a workers' comp claim when the person did not get sick at work. And the workaround that the politicians believe can happen is that if somebody gets sick at work, we're going to assume that it is because of work, but the employer has a chance to bring evidence that the employee got sick somewhere else. Honestly, with this virus, I don't know how you can prove either way, but that's what the law says. Another point that I want to bring is a law, AB 3075, which deals with successor liability. And it is essentially that when a business changes ownership, the basic rule is that any claims that were there before disappear because you have new ownership. So whatever the prior owner did, that's on them. The new owners get clean hands and they start a new business. And this doctrine of trying to ask the new owners to pay for what happened or the claims that were there before is not new. What is new is that now there is a law that says that it is easier to prove that the new owners are also liable for the wages that were owed by the prior employers. So be mindful. If you buy a business, be mindful that you may be on the hook. If you're selling a business, be mindful that the new people buying the business may ask you for some sort of, indemnity if somebody brings a claim, or some sort of set aside or reserves because of this new law. And beginning in 2022, the corporate filings with the Secretary of State are going to have a new line, which is going to say essentially, do you owe wages? Is there a judgment against you or something like that? So it's going to be public information, whether there are wage garnishment judgments or debt for wages in the Secretary of State information for corporations. And that's new. Lastly, minimum wage went up. I know that everybody knows, but just checking, is $14 for employers that have less than 26 employees. I said that wrong. $14 for employers that have more than 26, $13 for employers that have less than 26 employees. That's a new rule. It changed. Be mindful, because the other day I received a call of somebody that, by the end of January, they still hadn't changed their payroll. So they have a hole to cover there, but just be mindful of that. All right, so next slide.
Yes, and for this slide for our panelists, if you look at the 12:20 mark, there was in the chat box, there is a slide that's pertinent. There's documents on Javier's website that is pertinent to the next slide. So I'm sorry, it's not this slide, it's the next slide, it's the poster slide, but I just want to preview it right now.
Yeah. Okay. So if we were live, I will ask, you guys recognize this? Have you seen this before? And most people will say, yeah. And most people will say, no, what is that, right? So this is where all of us shake our heads up and down and say, yeah, I know what this is. This is a notice to employees. If we can take a step back, this is a notice to employees under Labor Code Section 2810.5. It is a form. It is a PDF. It is on the web from the state of California. But the reason why I'm taking time to discuss this is because this form essentially gives the employee information about who the employer is, how much they get paid, who the workers' comp carrier is, the pay sick leave available to the employee, and the contact information of the employer. If you fill out this form, you're going to check a lot of boxes of compliance with the state. And if you don't have this form, the employees can bring a claim for penalties not only because they didn't receive it, but for penalties because their coworkers didn't get it. So my recommendation is that if you don't have one of these for every single one of your employees, get one today. And that way you're going to be in compliance. And actually people appreciate when you give them this form because it has a lot of useful information, especially the workers' comp part. Because some people say, oh, I was ignorant. I had no clue who the workers' comp carrier was. I couldn't make a claim. And our comeback is going to be, well, I gave you the form, so no surprise. Now, if we can go to the next page, Chris, please. The posters and pamphlets, as we know, the state of California requires for employers to give certain notices in the form of not only putting posters on the wall, but also to physically hand pamphlets to employees at the beginning of the employment relationship. And we all do, right? At the beginning of the employment relationship, we hand out these posters. To be clear, there's a ruling that says that it can be done by electronic means. So an email, a text, a link to a website is valid now, but as of last year, you had to physically give them a piece of paper. But the reason why we're talking about this is because during this pandemic and last year, state employees took the time to update these forms. If you ask me, they had nothing better to do, so they just updated them. Some of them now look really nice. So these are the notices that employers have to give at hiring, right? The 2810.5, which we saw, the paid sick leave policy. We are all required to offer paid sick leave. So either you create your own policy or you use the form under 2810.5, and that's good enough. The harassment, discrimination, and retaliation prevention policy must be in writing and must be given to the employee, so says the Department of Fair Employment and Housing. So we have one of those. The injury and illness prevention program has to be in writing, has to be given to employee, so says Cal OSHA, and we have one of those, so we can check that box. And then at hiring, we have to give them all of those forms. In the chat box, I believe that Chris has already or will now put a link that you can follow to download these forms. And I'm talking about the state of California notices to employees. You can download them. They're public information, so you can either get them from my website or get them from the state. If you need a harassment, discrimination, or retaliation policy, it's a 2-page document, very straightforward. A paid sick leave policy is 2 paragraphs, and the IIPP, Cal OSHA has a website that if you answer some questions, the website will generate an IIPP for you. So either you get it from an attorney or you get it from Cal OSHA. They have a tool to craft your own, which is pretty good, All right, so how are we doing on time?
Yeah, so we are at 12:54. You're right, Javier. Vicky has reshared the link with all the posters and pamphlets from your website that is in the chat box. So we have about 5 minutes. Javier, I'll keep my eye out for any questions. I'll mention to our attendees if there are any questions, please ask them now. We appreciate it. Other than that, I don't think want to mention harassment, but that's where we're at right now, Javier.
Great. So let's just continue then. If there's any questions, let's just interrupt, because what I would like to do now in the next slide. Okay, is this sexual harassment? Let's go back to the picture. Is it? Of course, you cannot answer. Some people say absolutely, and some people say, well, it depends, right? It depends. And we can analyze that picture for sexual harassment. But the point that I'm trying to drive is that when we talk about sex and sexual harassment, everybody kind of knows what sexual harassment looks like. But sometimes we forget that there can be harassment that is not related to sex, which takes me to the next slide. The single most important factor in order to determine if a conduct crosses the line and becomes illegal harassment is what the motivation, the why. Why is this person doing what they're doing, right? So any conduct that is based or motivated on animus, which is just a fancy word attorneys like to use, right? which means hostility or ill feeling against somebody who's a member of a protected group, that can be harassment. To say it again, any conduct that is motivated by a dislike of somebody who's a member of a protected group, that could be illegal harassment. To use an example from the recent election, if I am a Democrat and I don't like Republicans and my conduct is motivated by my dislike of Republicans, that could be illegal harassment. If I am a Republican and I do something to a Democrat because I don't like Democrats, that could be harassment and it could be illegal. Now, going to the next slide, there are 14 different reasons why any conduct that is motivated by dislike towards people who are members of this group could be illegal. So what I'm trying to dramatize here and to illustrate is that it is not only sex we have to be mindful of, we have to be mindful of all of this, because any comment, any joke, haha, or something that is funny, or anything that is intended to demean, to put down, to ridicule, to make fun of, could be crossing the line and could be illegal if it is motivated by ancestry. What does that mean? People that came before me. Age. Now, interestingly, age is protected only when people are over age 40. Color, which to me means the color of the skin. Disability, which is physical or mental. And this is important because the physical disability kind of, we can see it, but the mental, we cannot see it. So we have to be mindful of that. Genetic information. Interestingly, back in the day, employers were able to do genetic testing of their employees. That is no longer allowed. Gender, which means whether I am a man, a woman, neither, both, right? So it includes gender identity and gender expression, not only what I represent, but also what I self-identify. Marital status, where somebody's single, married, divorced, widower, right? Medical condition, which is different from disability. A medical condition is temporary. A disability typically is permanent. Status of a veteran, military service, national origin. And national origin is interesting because it's not only where you come from, but also where the people before you came, which is kind of like ancestry. And it also includes the use of language and the use of documents. For example, California allows for undocumented workers to get a driver's license. So if you ask for a driver's license and the person shows you the California driver's license that is not for people who are authorized to be here, you cannot use that information against the employee. That could be harassment or discrimination. Race, which to me is similar to color, but it's not. Religion, and religion not only includes whether somebody wants to express their faith or believe in something or don't believe in anything, but it also includes the way they dress and the way they're groomed. Some people keep a beard, some people shave their heads, some people put some garb, head coverings. All of that may be especially protected by law. Sex, which includes pregnancy, childbirth, and breastfeeding. And concerning breastfeeding, something from 2020, back last year, 2020, there were new rules about breastfeeding and the space that is necessary to provide for mothers to breastfeed or to extract. So that's something that's not 2021, but be mindful that the 2020 rules are still there and still new to most of us. And finally, sexual orientation, especially protected and can cross the line. Any conduct can cross the line and become harassment. And this is who I am. That's my email. If you have any questions within reason, I will answer it by email, or you can call me. And with that, I think we're on time, right, Chris?
I think we are. I definitely want to thank you guys all for attending. I want to thank Javier for doing a great job, and thank you, Vicky, and the Dana Point Chamber for having us. Really appreciate it. So we appreciate you all for being here.
Thanks, everybody. Hope you found this informative. We will send out a link to the presentation as well as the recording of this webinar, and I'll make sure to CC Javier as well, so that way you can contact him with your very light, fluffy questions. And again, he's not your personal lawyer. But other than that, again, thanks to everyone, Chris and Javier, obviously, thank you for your time, and we will talk to you guys soon. Check out Dana Point Chamber chamber.com to see other upcoming webinars and events, including a little town hall with Congressman Mike Levin on the 25th. We'd love to have you guys attend. So with that, have a great rest of your day.
So
Thank you.